Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Welcome to our bi-weekly, every 2-week call, which we hold for the community. This does not create an attorney-client relationship as the disclaimers tell you when you log into the conference, and the call is being recorded to be disseminated publicly. We do the best with what information we have. This is not a substitute for an in-depth consultation. In fact, we might be pressed for time in that we want to answer all the questions that have been posted. So we may not be able to do a thorough job, as thorough as we would in a personal consultation. But at least we'll be able to give you some direction and sometimes complete answers. With that, let's just make sure you can hear me. So
the conference is now in conversation mode.
Can you all hear me okay, guys? Can you hear me?
Yes.
Okay, good. Excellent. Thank you. Okay.
The conference is now in presentation mode.
So I've marked 2 questions as frequently asked. First frequently asked question, I want to deal with them first. Let's begin with that. Let's begin with the salary requirement, okay? So this question, the question number 3, focuses on what to do when an employer is paying me less salary than required. Okay, first deal with that general thing, and then we can talk about a couple of other things that stem from that. So under the H-1B regulations, the employer is required to pay you a certain amount. Now, how that amount is calculated and ultimately computed is a little complicated. But keeping in mind, let's say just the simple process that let's say there's a wage X that you're supposed to be paid. But the employer is paying you less than X. What are the consequences? Is this legal, illegal? What do you do about it? Well, first of all, when you are getting paid less than your H-1B required wage, and I won't get into that, what required wage is, that's complicated. But let's say we understand what the required wage is. In this case, SHA 1212 does. He knows what the wage is. Can it be argued that you are out of status because you're getting paid less? Well, it can be argued, but it's not your fault. You are there for the duty. You are working your hours, and they are not paying you. What do you do to protect yourself, and what are the consequences of them doing it? Actually, that's a silly thing for any employer to do. Why? Because the wage and hour division, remember this agency, the wage and hour division of the U.S. Department of Labor, if you Google them and just say LCA complaint, wage and hour division, DOL, I think it's the form WH4 that shows up. If you file that complaint against the employer, the Department of Labor will go in and get your money for you. Not only that, if you transfer to another employer and you have filed such a complaint, it is a great protection for you against any violation of status assertions by the USCIS. Because you are available, you tried to work, the employer basically messed up your payments, and you are not at fault. So that kind of a situation, a complaint helps. The employer is also required not only to pay the wages, they are required to pay them in proportional installments on the periodic basis they use. So if the employer pays on a weekly basis or a monthly basis or bi-weekly basis, whatever they choose, they just can't change it. If they are paying everybody on a monthly basis, they are supposed to pay you on a monthly basis as well. And these are pretty much equal installments. They can be more, but they can't be less than what would be required. So not only is the employer required to pay you the wage, they are also required to pay you in appropriate installments. They can't just say, we will pay you 10 months this much and the last 2 months we'll cover it. Exceptional circumstances, it can happen. For example, we had a client who had a miscalculation. Neither the employer nor the employee noticed that the employee was about $6,000 short of the payment. It wasn't intentionally done. It was a mistake. So at the end of the year, we asked them to just make it up. And that should be okay. Mistakes can happen, but when an employer deliberately underpays and doesn't pay equal installments, they can be investigated and your money would be recovered. And it also protects you if you file a complaint against such an employer as you are leaving or after you leave. Your money is safe. It's going to come back to you. Okay. So the question here is, my H-1B was approved in November last year. They started deducting my taxes, but they haven't started giving me my salary. So that's a very dangerous thing for them to do. You can definitely complain to the Department of Labor, Wage and Hour Division. Do I need any document from my employer in writing saying they'll pay me at the end as bonus? Yeah, if they give it to you, I don't think they will. What if I want to go stamping? You won't get stamping with this kind of a history unless you file a complaint. I would suggest you move over to another employer. Can I switch jobs? Yes. Switch jobs, file a complaint when you switch jobs. And if the USCIS comes back and says, well, you weren't paid, and the answer is, it's not my fault. I was doing my work. You should be okay. My current employer also filed H for my wife. It's pending with the USCIS. Do I have to file H4 again? This is complicated. I actually always like to file H4 again, even though it's not required. I don't think it is required. But I like to do it anyway, because when the old employer revokes the H1 when you are gone, sometimes the H4 can get messed up along with it. It's just so much easier to just file it again. Okay. Yes, so I already covered question number 5 and 6. The Department of Labor Wage and Hour Division is going to get your money back for you. In fact, employers who do stuff like this get into some major trouble, because that shows that they're probably doing it routinely. And if they're doing it routinely, their company is in a heck of a lot of trouble. Okay. *5. Press *5 if you have a follow-up question on this discussion. Nothing new. *5 if you have a follow-up question on this discussion. Okay. Let's go to the next frequently asked question. I had another one I marked. This also comes up quite frequently. Now, once you have your green card, after X number of years, let's say 10 years, you have to renew it. Now, renewal of the green card is an administrative process. Okay, remember that. It isn't an investigation into what you have been doing, etc. So even if you had a DUI, I hope you don't, that won't come up in the renewal. I haven't seen it, and I don't think it's a part of the process. Okay, so once you get your green card, what happens then? Let's say you are working as a technology consultant. A couple of months after you got your green card, you quit and you started your own business. You got a gas pump. Is that a problem? I don't think so. I mean, this discussion can be longer than I intended to be for now, but I want to make a point that after you get your green card, as long as you did not have an intention to leave immediately, something came up that presented an opportunity, you're allowed to take it, even if it has nothing to do with your job. So from being an IT consultant to a gas station owner is a big jump, but that's okay. You've got your green card. You paid your dues to the system. Okay. So in this case, this gentleman's question is, if I go for green card renewal, I'm not employed right now. Is that going to be a problem? No, it is not. Can I renew my green card or apply for citizenship? You can actually do both. And if you go to the USCIS website, it tells you, if I remember correctly, that if you have more than 6 months remaining on your green card, you can apply for naturalization and you don't have to worry about renewing your green card. How long one can stay out of the country? Okay. This is a very complicated and long question. It isn't something I can again answer in detail in this short conversation. But the basic idea is, if you leave the United States for less than 6 months at one go, usually you are okay. You're not questioned too closely. But more than 6 months, they question you very closely because of certain technical reasons, or they can. Okay. At 1 year outside, you lose your green card automatically, unless you have something like a re-entry permit. If, on the other hand, you are a US citizen, there is no requirement that you have to stay in the United States. You can stay anywhere in the world. Never have to come back again, and you would still be a US citizen. Okay. *5 if you have a follow-up question on this discussion. Press *5. No new questions. Any follow-up on this, please? All right. So these were the only 2 questions that I thought were frequently asked. Now you guys have to be a little quicker, okay? Don't do this to me. You are young people. You should be. Let's see. Area code 925. Where are you calling from?
Hi, I'm calling from California.
Yes. Go ahead, please.
I was confused whether I should, ask the question here or later. So
no, right now, hang on. I'm only going to do the posted questions.
No, it's about the green card.
A renewal?
Yes, about that same question.
Oh, yeah, absolutely. You can. Follow-up questions are welcome. Mm-hmm.
So basically, there are many rules online that, you have to be in the country for 180 days or you can go out and come back. So what's a good website to kind of read exactly how you can maintain a green card? Like how many, what are the rules? Where can I read that? Because if I go check online, it's very confusing sometimes.
Okay. You can, of course, you can get a consultation with a lawyer, but the only websites you should trust completely are the ones that have a .gov extension, because government websites have the force of law. If they write something there, you can rely upon it completely. Private websites will give you a lot more information, but you cannot hold anybody accountable for that information. Okay. So I would, if I were you, I would look for, write this down, Board of Immigration Appeals Decisions, BIA. Okay. Because BIA deals with things like abandonment of green card. If you get deported because you surrendered your green card or you abandoned it, they are the ones who deal with these issues. So you can look at BIA decisions. You can also look at USCIS policy manual, which is on uscis.gov website. Okay. That's what I would recommend.
Okay. And Board of Immigration
Appeals, BIA, Board of Immigration Appeals. Yep. Okay. Good luck. All right. Okay, so let's go on to our regularly scheduled programming. Question number 2. So this one deals with downgrading from EB2 to EB3. What is the interview process, job responsibility, wages, and when should I change jobs? So this person, I don't know, lady or gentleman, was working for an employer A, and they got their I-140 approved under EB2, then moved to employer B, and when the dates became current, using employer A's process, and obviously employer A is willing to take them back, they filed I-140 485. So the questions that come from it are as follows. Could you please explain briefly the interview process of green card? Not really, because there's no brief about it. But suffice it to say that they can question anything these days, specifically your background, what you have been doing, and they can ask, why did you leave employer A? It looks like you didn't really want to work with them. I have dealt with this before in several earlier phone conference calls, and you would see the recordings in the frequently asked questions. So we've dealt with this issue. This can be questioned. If I plan to join employer A before my date becomes current, my salary will be 20% lower than the perm. That won't work. because they, under no event can they pay you less than the perm salary. They could pay you less than what you're making now, but they can't pay you less than, or at least the future job cannot pay you less than. Because remember, the green card job really begins when you get your green card. Before that, you are either on H1 or EAD, which can have different wages. But if you are doing the same job now as you would be when you get your green card and you're getting paid 20% less, that could become problematic. How do you explain that? It can be a point of scrutiny. So they depends upon whatever they focus on. And you asked about generally acceptable period of time I work before I can change jobs. After you get your green card, well, I've mentioned this many times before, and it'll be nice if you guys could review the frequently asked questions before you post. I have mentioned this many times before. So go and look at the frequently asked questions. There's really no time period that I can give you. But the bottom line is, you should have the intention to stay indefinitely at the time you get your green card approval. But after getting the green card approval, if situation changes, you have a better job, etc., you can take it. But if you go in with a preconceived intention to leave at a certain period of time, government can question it. I don't know how far that's feasible, but they certainly can try. Okay. *5 if you have a follow-up question. *5. Press *5 on your phone if you have a follow-up question on this discussion. Okay. Let's go on. Oh, there is one. Guys, what's going on? Oh, am I in too much of a hurry or are you too slow? Let's see. Area code 201, is that New Jersey?
Yes, sir, New Jersey.
Yes, sir. Go ahead. What can I do for you?
Sir, my follow-up question is, my wage question was, my salary would be more than the minimum wages required, but it is less than the offered.
No, there's no such thing. There's no such thing because once a salary figure has been put on the perm, that is your salary. The prevailing wage is not your salary. Okay. So,
okay.
Yep. All right. Good luck. Let's go to next question. This is question number 4. They want to delay their move to the United States after they get their EB1C green card through consular processing. And 2 to 4 years. That's actually a problem. But what you can do is, you can come to the United States, join the job, even if you do it for a couple of months or a few weeks, and apply for re-entry permit. Re-entry permit, which allows you to stay for up to 2 years outside the United States without losing your green card. And if you want to extend that even more, you could come back again, apply, wait for the biometrics, do the biometrics, and let the extension be sent to you in your home country. So look into re-entry permit. Re-entry permit. That would help. Okay. And you can hire your own lawyer for this. You don't have to go for the lawyer the company hires. And normally, when they issue you a green card at the consulate, it is in the form of an immigrant visa with an expiration date. You have to come to the United States before that date. Arrive at the United States before that date. *5 if you have a follow-up question on this discussion. *5. Okay. So the next question, number 5, is, can we do adjustment of status for ourselves and NVC, which is consular processing for our family members? The answer is sure. Why not? I don't see any problem with that. What are the steps involved? So you already have a lawyer. So guys, I'm a little uncomfortable giving opinions to people who are already represented. One, you have your own lawyers. You should talk with them. And leave the time open for people who are not represented or who are confused about the representation. Okay, let's try to do that. So talk to your own lawyers, see what they suggest. But definitely it is possible, and all it takes is an extra form I-824, and your lawyers can file it. I don't see any problem with that. Nobody can tell you what the timelines are. Even the estimates that anybody gives you, they are worth very little because the times are so widely divergent during this time. Can my son travel outside the US and return? He will need a visa or he will need an advance parole. So when you file adjustment of status, you will also file for his advance parole. In order to travel, either he needs an H4 visa or an advance parole. H4 renewal can be done in Mexico, Canada, any other country. I don't see any problem with that method. So the bigger problem is the consulate that you want to go to, are they taking third country nationals, what is called TCNs? And if so, are there any particular rules you have to follow? It's because of the COVID situation. Theoretically, you can apply anywhere in any country in the world. Okay. I don't see any shortfalls or pitfalls in this. *5, if you have a follow-up question on this, *5. Okay. So Sweta has a question number 6, that talks about doing a name correction with an I-140 pending. Can I combine it with a request for premium processing? Yeah, I think it'll be a little bit easier actually if you do it during premium processing. The way you would do it is, you would probably open a service request and tell them that you have a problem with the form, and tell them that you are upgrading to premium processing. And during premium processing, it might be actually easier to do the correction. Okay. Now, do I need to wait until I get updated receipt to upgrade to premium? No, I don't think so. You can do the premium processing. So once you open a service request, you can also be doing premium processing at the same time. After my I-140 approval, if my spouse moves to EB3 EADI and remain on H-1B, can we both apply 485 in EB2? I don't see why not. I keep getting these vibes from people as though if you have used the EAD on EB3, I have not yet found a reason why that would stop you from converting to EB2. I really don't see why that would stop you. I keep thinking of, and I've heard people say that, I've never really understood the reason. So until I'm told the reason and convinced about the legality of the reason, I don't think there's any reason that should stop you. Okay. *5, if you have a follow-up question. Now, the next question, which is number 7, is a little too detailed for my liking. Too many issues and a little bit of time issue here, but I'll cover it broadly. What I would suggest is to keep in mind the most important things. When you have a preconceived intention to apply for a green card, government can take objection to you using a tourist visa to do that. So if your parents come here on a tourist visa, and you've done the homework, I can see that. If your parents come here on a tourist visa and try to adjust status to green card within the United States, government can take exception to that. Now, and interestingly, if you look at the language of the law, immediate members of family of the US citizens should not be subjected to this standard. But at least under Trump administration, government was routinely doing it, and it was causing a lot of havoc. Okay. So keep that in mind, that there should be no preconceived intention. But here's an interesting issue. What if the intention is yours, the son's, not your parents? I think you are okay. Why? Because they are coming innocently. And you're not also doing anything fraudulent. You are not required to not have the intention to apply for them. They are required not to have the intention to apply. All right? So keep that in mind too. It's a fine distinction. They have never overstayed. They are 65, 70. Will my Indian birth certificate be honored? Yeah, you have the certificate of non-availability, and you need a certificate of non-availability along with a couple of affidavits from people who were alive when you were born. The same for parents. Now, can you secure it now if you want to file for green card in 2022? I'm just a little hesitant because it creates that problem that we talked about. So it does create a presumption of preconceived intention. So I would avoid that until I'm good and ready to file. So it's okay for them to change their mind after being here 3-4 months. Okay. Is there a secondary form of proof required in addition to the birth certificate? Yeah, we actually give them everything that they ask for. Technically, the government should only require proof of non-availability, which is a letter from the municipal corporation or the village panchayat or the taluka authorities that say that there's no record of this birth, and then 2 affidavits from people who were alive when your parents were born. They don't have to be adults when your parents were born. Okay. Marriage certificate is also easy. Same idea. You will present affidavits from people who attended the marriage. Two affidavits. Is there an option to using genetic or DNA? Yes, of course. You can always do DNA. You can offer to do DNA testing. Where do I find all the documents required? Just go to the USCIS website and read the instructions on the website as well as the form instructions. Okay. So the questions were not that lengthy. I thought it was a lot more. Oh, processing times. I don't know what the average is. Guys, remember, I don't do coding. I do system design. So I do the strategy part of law. I don't keep track of all the details about the form processing, etc. I may know sometimes, but I have no clue. Plus, I do know that these estimates are thoroughly unreliable, especially during COVID-19 times. I saw the estimate, I think it was for an N400, a naturalization. I think it was North Carolina, and the estimate was 9 to 36 months. So that's 1 to 3 years. That's not an estimate. That's just nonsense, right? *5 if you have a follow-up question. *5. Okay. This one is coming from area code 614. 614, where are you calling from?
I'm from Massachusetts.
Yes, sir, Massachusetts. Tell me, how can I help you?
So, regarding the point where if we don't have any documents created in advance, even if we plan to file 2 years or 3 years from now,
right,
and parents are here, and I think I've heard that, wait 90 days or so before filing for a green card, and that way you don't have the intent issue. What I struggle with is if parents are here and the documents need to be then created in India, how does that logistically happen? Because, one parent may be born in one state, the other may be in another state. They may be, how do people logistically manage the challenge
actually,
of getting the affidavit from the people?
Yeah,
and so on?
Most people will either have a family member or a friend go. Some people hire lawyers in India. Some people there are actually services, I understand, who do this. I don't know of any, but I've heard that there are. So that's how typically people do it. Really, what do you need? You need only one thing. You need the certificate of non-availability from the municipal corporation. Okay. And other than that, you just need 2 affidavits. The affidavits under US laws don't have to be on stamped paper. They can be on plain paper, and they don't even have to be notarized. Remember, USA being a secular country, does not require an oath. An oath is basically an oath in front of God. You can actually swear under penalty of perjury, and that doesn't require what in India we call an oath commissioner, and here we call a notary public. So an oath is not even required under federal laws. Therefore, the only thing you really need somebody to run around for is the municipal corporation non-availability. Okay.
But then for the marriage certificate, you can't do that.
There is no marriage certificate. There's only, in India, you don't get marriage certificates unless you get married in court. So you have to get affidavits from two people who attended the marriage.
Okay, so for both the marriage, for proving the marriage and for proving the birth, all you need is the affidavit, and then the municipal corporation does not need the actual person born to be there.
I can't comment about the local rules, but that's how people do it. I don't know if that's how it is everywhere. Okay. Good luck.
Yes, thank you.
Okay, so next is question number 8. So spouse is changing from EB2 to EB3 with a new law firm and service center. I don't see why that should be a problem. The only thing is, when you have a 485 pending with another lawyer on the 485, you just have to make sure you tell the government which lawyer will carry the case forward. Okay, so if you are filing a completely new I-485, then there is no problem. But just make sure that your new law firm knows there's another law firm on the case, so that the old law firm does not necessarily get burdened with any other paperwork. And make sure that your old law firm also knows where you are so they can forward you the documents, because the government is not really precise about these things. But it's perfectly okay to do that. Does your wife need to downgrade? No, not at all. You are the primary. She has her own I-140 EB2. She doesn't have to downgrade. You are downgrading, and she's getting her green card through you as a derivative. So you are the hero of this show. Star 5 if you have a follow-up question on this. Star 5. Okay. Question number 9. Maintaining status. There's an employee who has filed for an H-1B as a beneficiary till November 2022. I was approved in the middle of January 2021. The validity is there up to the middle of 2023 September, and it came with the I-94. My current employer has applied concurrently for I-140 EB3 and I-485. Currently it is pending. No receipts yet. My current employer has applied for an H-1B as a beneficiary. The position got cancelled. He got an RFE about the maintenance of status. Meanwhile, another client has offered a project for me. My current employer is going to file an amendment to the current H-1B where there's an RFE. Okay. As the original H-1B has not been approved yet, I'm under the assumption that my H-1B will be approved, but not with change of status. Well, let's just make sure that I understand your situation. You got the H-1B approval, came with the I-94, filed I-140, 485 concurrently through another employer. Current employer has also applied for an H-1B. There's an RFE and they're doing an amendment. So yeah, worst case scenario, you will be given the H-1 but not the I-94. You will have to go outside the United States. We actually were in a litigation in a similar circumstance, not exactly the same situation. There was an extension pending through the old employer when my guy moved over to another employer, filed for a transfer. They approved the transfer and they denied my status, saying, while you don't have an approval, old status has expired. And I said, wait a minute, but I have an extension pending. And there is really, if you look at the regulations, you're misreading the regulations. The government didn't fight us on that. They just settled the lawsuit and gave us the H-1B Would that help you? I do not know. But there might be some room to argue there. But that's the worst case scenario, so what? If you have to go outside, hopefully things are only getting better with time, and you should be able to get visa stamping actually from any country, not just India. Okay? If my change of status is not approved, can I still work on the approved H-1B as I-485 is in pending status? So your H-1B already approved with the new employer is for a particular client and project. You can't use it if it is no longer applicable. But if it is still applicable, you can use it. Okay. I hope you're here because I hope I understood your questions. *5. If you have a follow-up question, *5. I think I understood your question, but I could be wrong. Okay, you're not here. Okay, here. You are here. Good. Let's see. Area code 802. Where are you calling from?
Right now, I am from Virginia.
Okay. So, did I understand your questions correctly? Are they answered?
Yes, partially. But sorry, I should have framed the question very well. I tried to take as less space as I could.
No problem.
The information
No
so that
problem.
it may not burden you.
No problem.
Yes, my situation is something as such. First thing, I came after I came here. My previous I-94 was valid up to November 5, 2020, and then one employer has filed for my H1, and it got approved on January 15.
Okay.
That is the first thing. But my current employer, he has applied for my
I have a
H1,
question.
after
One second.
Yeah.
You came in on an H-1B from employer number 1. Employer number 2 filed for your transfer. You got the employer number 2 transfer approved. Now there's an employer number 3 in the picture. Did you ever work for employer number 2?
And I got an offer, but I got better offer, and that employer 3 is who is sponsoring my green card.
Okay.
So I need to be with my employer 3.
So how does the timing work out? You came into the United States. Did you work with employer number 1 who had first sponsored your H1?
Yes.
Okay. So while
but I moved.
okay, wait. Just go with my questions.
Sorry.
So then you transferred over to employer number 2, and you worked for them or no?
No, I did not work.
Okay. So you stayed with employer number 1.
No, I transferred with employer number 2. He asked me to wait till I get my approval. Meanwhile, my previous employer, I tried to contact my previous employer who has filed for my I-140 previously. So I contacted them, and
Okay, I have absolutely no idea what we are talking about. Okay, because the timeline is so messed up. I just don't understand what you're saying. So, how many employers are in the picture? 2, 3, or 4? I count 3.
3.
Okay. So, first employer applied for your H-1B. You came to the United States, correct?
Mm-hmm. Yeah.
You worked for them. Employer number 2 applied for transfer, correct?
Right.
You did not join them.
Right.
While the transfer is approved, employer number 3 also filed for a transfer, correct?
Yeah, before the transfer was approved, employer number 3 has filed for a transfer.
No problem. All the time you are working with employer number 1? Okay.
No.
Did you quit employer number 1?
November.
Hang on. Did you quit employer number 1 after employer number 2 filed your application?
A little before that.
But within 60-day grace period.
So, yes.
Okay. So you maintained status. Employer number 3 filed your transfer. When that got approved, you joined them, correct? Okay.
No, I joined them when it is in pending status itself, employee number 3.
Yeah,
Because
that's fine.
incidentally, the
Yeah,
employee number
yeah,
3,
that's fine because you have
employee
a.
number 3 is the same one who has applied for my green card previously.
Got it. Okay, so you joined employer number 3. Now,
Mhm.
employer number 3's case is still pending, right?
Yeah.
Okay, so you are concerned whether you will get change of status or not, and the answer is.
Yeah, because
Go ahead.
because there is one small thing. Um, the employer number 3 has applied for one position before.
Yeah, I
But
got that.
because
I
of
know
the
I got
various
that. I got that. And
vendor side,
that project fell through and they are doing an amendment. So yeah, I think the worst case scenario, you'll have to
right,
step out the United States. So you may not get change of status because of all these complications. Okay. So the
right.
question is, can I still?
That is one thing.
Okay. Look, I'm running out of time here because I've
Go.
got another similar number of questions that I answered. So you're gonna have to make it very quick. You have a lawyer, talk to them. Ask me a question that you really don't understand. I'll try to answer it real briefly.
Right, right. Because I know one thing, or at least I assume this is to be correct. One thing, whenever we are adjustment of status is in pending, if we go out on advance parole, we can come back on advance parole, but with the previously approved H1, we can still work on that on H1 status, but with advance parole. So similarly, if I don't go out because my adjustment of status is still in pending state, can I work without stepping out? Because legally I can stay. I know that
Okay.
part because
Okay.
adjustment of status is
Okay.
in pending state.
Okay. So the question is, can I work? And the answer is, you want to work for employer number 3, your current employer. The current employer had filed for an amendment for which they filed for an extension for which they got an RFE, and while that is pending, they are now trying to file an amendment. As long as these two are still going on, you can continue working, but the moment their RFE is denied, you have to stop working.
Okay.
Okay?
Okay, I got it.
I gotta go on. Good luck.
Thank you.
Okay. Sorry, guys. Like I said, we do have limited time. We do the best we can. Keep it straightforward and simple. Number 11. Impact of H4 EAD expiring on spouses. Okay. I'm currently working full-time on H4 EAD, which is expiring next month. Spouse filed for adjustment of status. EB2 to EB3 downgrade. We've got the EADs. Okay, yeah, these are, I think, husband and wife asking me the same questions. Because I merged these two, they look like the same questions to me. So, okay, now my renewal for H4 and H4 EAD has been pending for past 6 months. Question number 1, can I start using my green card EAD while my spouse remains in H1B? Absolutely. If so, what is my status while working on green card EAD? Do I get I-94? No, you do not. You are legal because you have a 485 pending. Your H4 goes away when you start using the green card EAD, but that's not a big deal. You can always get the H4 back by stepping outside the United States to get a visa stamp whenever you need to use it. Which is your question number 2. You have to go outside USA to get a visa stamp. What is the best to do and risk? I like the green card EAD a lot better. And again, in my view, you can still do interfiling for EB2 when the final action dates become current. My spouse is in the 9th year of H1B. And if something gets denied, can he still continue working on H1B? The answer is yes. So if the 485 gets denied, he can still continue working on H1B. Why not? He will be able to work till the end of the process. And the next set of questions look like a mirror image of the husband asking me the same questions, unless I've misunderstood them. My wife is currently on H4 EAD. It'll be expiring next month. My H1B has expanded. Actually, I don't, maybe not, but they are the same questions. If my wife gets green card EAD, can she start using it right away? Absolutely. Is there a procedure to abandon? No. There's no procedure, nor do you need to abandon H4 EAD. Can I remain on H1B while she's on EAD? Absolutely. Does it affect my H1B status? No. Once she starts using her GC EAD, can she go back to H4? Yeah, she has to step outside USA. If for any reason R485 is denied, can we apply for H4 while she remains in the US? No, she'll have to come back with an H4 visa stamp. *5 if you have follow-up questions. *5 if you have follow-up questions on this. Okay. Area code 315, where are you calling from?
Hi, sir. I'm calling from New York.
Yes, ma'am.
My follow-up question is if my husband's I-140 on E2 and EP3 gets denied, can he be still on H1 status?
Yes, I already answered that. Absolutely. Until the H1 expires, he can stay on the H1.
Okay, good to know that. And one more question, sir. Like being on H1B, my spouse, can he use the advanced payroll for traveling outside of the country?
Yes, he can, as long as he comes back to work at the same job from which he left. He would be considered to be still on H1B.
Okay.
Okay.
Okay. Does that mean that we are using EB3?
That has nothing to do with H1B. Okay.
I mean, using the advanced payroll just for traveling means using EB3 category?
Advanced parole is attached to your 485, not to your I-140. I-140 gives you the category. 485 can be changed from category to category. Okay.
Okay. Thank you, sir.
Good luck. Okay. Question number 12. Asylum. Sorry, I don't know anything about asylums. There is a follow-up question. Sorry, I didn't see that. Area code 216, where are you calling from?
Hi, Rajiv. I'm currently in Texas right now.
Yes, sir. How can I help you?
So I'm the one with the second part of the question.
It almost looks like husband-wife questions. That's not true, right? You're two different people, right?
Yeah, we are different.
Okay. I thought these were husband and wife asking the same questions. But go ahead.
I just want to confirm something that currently the H4 and H4 EAD is pending.
Right.
It's in process and USC is taking too much time.
Right. Of course.
So, and our 485 GCAD and advanced parole is also pending. But due to timeline, maybe we will get the GCAD first.
Sure.
So, when my wife starts using GCAD, what happens to the pending H4 and H4 EAD?
Well,
can they get approved?
No, they should deny that, because when you start using the 485 EAD, you no longer are on H4. H4 is out. Okay. If H4 is out, then H4 EAD is out.
Okay.
All right. So, and I'm actually, give me a choice between H4 EAD and green card EAD. I would take the green card EAD every time, because it has a 180-day grace period to continue working even after it expires, which you don't have in H4. So green card EAD is so much better. Okay.
Okay. That makes sense.
Good luck, sir.
Thank you so much.
You're welcome. Okay. Honest to God, those questions were so similar. I kept thinking maybe they didn't talk to each other before posting. Okay. Asylum, I don't know anything about asylum. Sorry, guys. The moving to a branch office with AOS pending. Now, this is tricky. Okay. In your case, your I-140 was approved and stayed pending for over 180 days. Then the company closed the location. When you filed adjustment of status, the office was still open. After 180 days of 485 pendency, where the I-140 is approved, you can actually use portability. So you're pretty safe because you filed in October, November, December, January, February, March. April will be 6 months, 180 days. So you're pretty safe. I don't think this is going to be a problem. I don't think you don't need to do any of this. Okay, my only concern is if you move right now, you have to file AR11, and AR11 could trigger an RFE saying that it looks like you have moved. Why should we not deny your 485? That's the only thing. So if you can, item number 3 on your questions, if you can continue to live in the current place till 6 months have passed, that would be the best thing, I think. Okay. *5 if you have a follow-up question. *5. Okay. Area code 541. Where are you calling from? 541.
Hi Rajiv, I am from Portland, Oregon.
Okay. Oregon.
Yeah, that is the same follow-up question. Yeah, so Rajiv, what happened? So my current branch was shut down, I think sometime in August.
Okay.
Before they filed my 485.
Now that could be a problem. That could be a problem. That's a much more difficult problem. Then I have to look at your labor certification. I have to see how it was filed. Everything I told you doesn't make any sense anymore then. If it shut off before you filed adjustment of status, you need to get together with your lawyers to review your paperwork. You could have a bigger problem than we can manage here. Okay?
Yes, Raju. So in October, when my lawyer filed 485, so we informed everything. Okay, this is the current situation, but they said that should be fine. So no problem for your 485.
They have the paperwork. I can't really predict what they are looking at. So until I see the paperwork, I won't be able to comment beyond what I just told you. Okay?
Okay.
Yeah.
Okay. So Raji, anyhow, so you're suggesting to move after 180 days past?
If the branch was still open, if it was closed, I have to look at how they filed the labor cert, what kind of representations were made. Was it filed through corporate headquarters, through the branch office? What were the conditions? So there's a lot of things that I've got to look at. I can't really give you the answer. If your lawyers say it's okay, I'm assuming this is not rocket science. They should know what they are talking about. This is not a very difficult issue of law. If the branch was open, or if it was okay to file the 485, I hope they are right. But I can't comment about whether they are not because I don't know the paperwork. Okay. So really, even say stay in the same place for 6 months doesn't make any sense because I don't know what the case is. If the branch was still open when you filed, then everything I said would work. Okay.
Yes, Raju. So here is my final question. So my branch still is open. We have some servers going on, but nobody is working on the branch because of the COVID. Everybody is working remotely, 100%. Everybody remotely. But we have the equipment, server still.
Okay.
Still my company.
All right. I know you want me to give you an answer. My answer is still the same. Until I see the paperwork, I can't comment. All these fancy shenanigans, the files are there, the servers are there, they don't really matter. What matters is, has the job moved out? It doesn't matter if the branch is doing some skeleton operations. I have a case where somebody is working from Iowa, and that company should have closed down many years ago. They were keeping the company open just for him. I recently just refiled his green card through the through the mother company because I don't think it's worth the risk. What are we doing here? I mean, we've got to be absolutely upfront with the government. Not that we have lied about anything, but it becomes very difficult to sustain a good faith case where you've got one employee for the company who's trying to work from there. Legally, I'm still right. I would probably still win in a court, but I have another option. Why should I wait for all that to fall on me? I just take care of it. So you should talk with your lawyers, make sure your managers, etc., are involved. I don't know what your case is. I gotta go to my next question, okay?
Yeah, Raju, thank you.
Good luck. Yeah, guys, don't bring me fact patterns that are so tightly bound to. I can't really give you a legal opinion without knowing the facts. I can tell you generically what the law is, which is if the branch is still open, you can file the 485. But if the branch is gone, is the job also gone? Or was the job located somewhere else? And that depends upon the green card paperwork. Next question, number 14 is, guys, we're not going to have time for new questions today. So we're just going to finish up with what we've got. Parent on I-140, impact on 19-year-old son and CSPA. We've been living in India for 9 years. Dad's I-140 was approved in 2011. He has changed his employer since then. Dates became current. Does my dad have to change his current employer during the consular process? Well, obviously, if he has left the old employer, the green card is over, right? Unless he starts a new green card, the consular processing doesn't mean anything. Because until he gets the green card and takes the job, generically speaking, there's more to it. That green card job is interrupted when he leaves. And so I don't know what your dad is doing exactly, but it does not look like he's working or even has a job offer from the old employer. You do get the time deducted 4 months during the I-140 for your CSPA calculations. How long does the consular processing take? Nobody can tell you. Maybe a year and a half, but that's just a guess. Doesn't really mean much. Yeah, I think the way I see it, and this is the way I understand your narrative, your dad used to work for a company, they got the green card I-140 approval, he moved companies, he's no longer with them. So he can't really do a green card through them, right? Unless they have the job open. If they do have the job open, why did he leave? So it's a little complicated. The better thing would be for him to start another green card through the current employer. But does that get you the 4 months that you need for CSPA? No, it does not. Okay. But also remember, if your parents are able to get their green card, they can apply for you as an unmarried son, daughter, who then gets the green card like within a few months to a couple of years. Look at that category, whatever that category, family category 2B or 2A, whatever that category is. So look what the time is. So even if you don't get the benefit of CSPA, they'll still be able to get you to USA fairly quickly if you are unmarried. Okay. *5 if you have a follow-up question. *5, because green card cannot go on unless that job is still there. And if you have left the job, it's a very strong presumption that the job no longer exists. Okay, no follow-up questions. Last one today is green card through brother or sister. My brother sponsored his 4 sisters 15 years ago. Now their turn has come and required paperwork has been submitted. So can I be a co-sponsor? So look, you can be a co-sponsor, and some of these issues I don't really know. I have to look at the forms. Anybody can be a co-sponsor for the affidavit of support. You don't even have to be related. So if there are family friends who want to do it, they can. Anybody who's a green card holder or US citizen can do it. But if you are filing your taxes jointly with your husband, you'll have to produce your joint tax returns. Do I need to give number of people I can co-sponsor? I don't know what that question means. I don't know what that question means. Do I need to give number of people I can co-sponsor? No idea what that means. If you are here, press *5. I have no idea what that question means. Okay, good. So what do you mean by that?
How are you?
Area code 267. Where are you calling from?
Yeah, Philadelphia, Pennsylvania.
Yes, ma'am. What does that question mean? Do I need to give number of people I can co-sponsor?
Okay, the thing is, since my brother has sponsored 4 sisters and their families, so now 7 of them are ready to move in. and
Okay.
the paperwork is being in process.
Okay.
They are kind of waiting for interview, but the thing is, like, one out of seven, she got an email from NBC that she should wait for call for interview, and others, three other families, they got co-sponsor letter that they are supposed to get some co-sponsors. So my question is that, like, I'm like a sister, I can co-sponsor my brother sisters without involving my husband, because no matter we are doing joint taxes. But if I can go ahead and sponsor, like, I don't want to put my husband on the liability of my brother or sisters, right?
Yeah.
So this is what my concern.
Yeah, no, you can. You don't have just because you are married, he's not automatically bound to all your personal obligations. If you decide to go buy a Ferrari in your own name, there could be an exception under state law, but as far as I understand, how can he be held liable for your responsibilities? As far as the affidavit of support is concerned, he's not responsible for any liabilities that you take, as far as I know. I don't see how he can be held to your loans and debts. Okay. So he should be out of it.
Yeah, good. This is what.
Yep.
Yeah.
So that's fine.
This is what my question was, because since I'm not working, like I have just rental income, around $30,000.
Yeah, but
and
yeah, but that looks okay. I mean, it still should be okay because it's above poverty level, and you can certainly sponsor people, right? So, and the government will let you know if
thank you so much.
and also, like I said, you don't have to be related. If there are family friends who want to do it too, they can. Okay.
Yeah. But since they are my family, my sisters, so
Right. Sure.
my
Of course.
concern was that if I can.
Of course. And also,
I'm on green card,
also, if this becomes an issue, their own assets also count. So whatever money, etc., they have in the bank also counts. Okay.
Okay.
All right. Yes. Good luck to you, ma'am.
Okay, good.
All right.
Thank you so much.
You're welcome.
Thank you so much. I really appreciate
no problem.
your input, and God bless you.
Thank you. Bye-bye.
Thank you. Bye-bye.
Bye. Okay, so let's see. I'm not sure where I am now. I've got two people, I guess, with similar questions. Area code 214, where are you calling from?
Hi, I'm calling from Pennsylvania as well. My question is a follow-up to the one that you just answered.
Yes, ma'am.
Just in a little more organized fashion. My question is, can the intending immigrants show their assets at the state to supplement the sponsor's financial requirements? And if this is the case, do we still need a joint sponsor?
That is a question of calculations and numbers. Okay. So can the sponsored person's assets be used? Definitely. Okay. There's no doubt about that. Will they be sufficient? That's a matter of calculation. Okay.
Right. Okay. So just to clarify, these intending immigrants are not the spouse of the sponsor, and they do not live or work in the U.S. So they are in.
Yeah, that's okay. That's okay. I had a case where the individual was coming from UK, and the husband was in USA. We were able to use her bank accounts, etc., to support her own case along with the husband's affidavit of support.
Is there any difference if the intending immigrants aren't spouses? They are the brothers. They are the sisters of the sponsor. Because I did read somewhere that it says that the intending immigrants' assets can only be used if they are either a spouse or they currently live with the sponsor. Is that the case in this scenario?
No. I think you're thinking of a different circumstance, and maybe I am confused by the question. But normally, let's say that brother X, who is a US citizen, sponsors sister Y. So brother X will give his affidavit of support, But Sister Y has any cash or cash convertible assets, quickly convertible assets, they can be counted towards her ability to support herself.
Okay. And will these assets be filled in the I-864 form? How will we show the...
I am not sure the mechanics. Like I said at the beginning of this call, I am only called in to decide the legal issues. I don't know exactly what the logistics are, but we do it all the time. Okay. How we do it, I don't remember, but it's definitely not an I-864 because that's a sponsorship affidavit of support. But I think it's some kind of a statement that goes with your own assets. Look at the forms, whatever forms you're filing. There should be instructions on how to do it. I know that we do it all the time. Okay?
Okay, thank you so much.
Good luck. Okay, guys, our time is up. We went a little bit over, but good to talk with all of you, and I'll see you again in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.